Welcome to our second hour of Court TV Live. I'm Julie Grant, and we're in a holding pattern. Oh, now we're not. Look at this. Just getting this image right now of defendant Shanda Vander Ark apparently passed the jail medical staff's screening exam. She had claimed she was having a medical issue that would prevent her from coming into the courtroom this morning. She was evaluated in our last hour. We were waiting and waiting, and apparently she's good to go. There she is with her brand new attorney. She's looking less than thrilled to be there, but nonetheless, she is there. This hearing is all about her claim of ineffective assistance of counsel. And so this is all part of what's called post-conviction relief. I'm going into professor mode here a little bit because there are lots of different mechanisms where somebody who's been convicted can try to put themselves in a better legal position. We talk a lot about appeals, where we're going to a higher court. This is before the trial court. So this is in the same courtroom, the same venue where she was tried, same judge. She's just claiming that her attorney was deficient, and in being deficient, deprived her of a right to a fair trial. Again, that is her claim, not saying that's fact. And I have to tell you, there are excellent criminal defense attorneys all over America who are in court at this very moment facing the same thing. This is a very common motion. Defendants who don't like the result of a trial will do anything they can to try to help themselves. And she's a lawyer, remember that. So she's going to exhaust every avenue. She's going to make that motion for a new trial. That's a separate motion from a motion for ineffective assistance of counsel and the request for a new trial by way of that mechanism. And then the appeal process is separate from those things as well. So what's happening here, she's waiving the attorney-client privilege. She is the privilege holder, so her attorney can't waive it. But we're going to see her attorney, Fred Johnson, a former attorney, I should say, the attorney who represented her at trial, being brought in to be questioned by the new attorney, who is sitting next to her. I am wondering if, I'm being told we don't have an audio signal yet. So we're just going to have to wait and see when the judge gets on the bench, when we will have that audio. We know that attorney Matt Roberts was ready to go. As a matter of fact, he's such a superstar. He came on opening statements this morning before appearing for the hearing. Here we go.
Good morning. Before the court is file 23110 FC. It's people of the state of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark? All right. Ms. Vander Ark appears before the court with her attorney, Mr. Ambrose, Mr. Roberts, as well as Ms. Bloomquist are here on behalf of the people of the state of Michigan. Day and time, the court is scheduled for a Ginther hearing, and technically a continued hearing from the last time we were here. We're delayed. There's been some concerns regarding Ms. Vander Ark's health this morning. Mr. Ambrose, if you want to go ahead and make a record of any concerns you have at this time.
Yes, Your Honor. I had a video conference with Ms. Vander Ark on Friday, this past Friday. It was concerning to me because she didn't appear to be her normal self, and so that concerned me. So I did send an email to the court expressing an adjournment if possible, just because this is an important phase in the whole appellate process, and certainly of utmost importance to my client that she's able to participate in a meaningful manner. And during our conversation on Friday, it just didn't seem that she was as up to speed or healthy. She expressed some health concerns that she was undergoing at that time, and so that's why I asked for an adjournment on Friday. What I understand is that what she told me this morning is on Saturday she had an episode at the Huron Valley Women's Facility, where she passed out for a short period of time, was revived, but she had a medical issue at that time. She's not feeling well today either. I know she was checked out by medical. Her blood pressure is higher than it is normally for her, as she self-reports. So I would be requesting an adjournment. It doesn't hurt the prosecution, I don't think, at all. It is, if anything, delaying this case keeps her in prison. I'd like to move forward if I could, knowing in good conscience that we're putting our best foot forward on a case like this, and have the 100% confidence that my client is able to participate in a meaningful manner. And I just don't think at this point I can, with any type of confidence, say that. So I would still ask for an adjournment. And I know that my client has signed a release for some medical records from Huron Valley Women's Facility to release at least the most recent episode that she had.
Okay, Mr. Ambrose, is she able to speak to you this morning?
Yes.
Not getting into what those conversations are, but are you able to converse with her this morning?
I can.
Okay.
She has a pounding headache, and it doesn't help. It's a stressful situation. I'm sure that's part of the what happens in these types of situations. But yeah, I mean,
as an officer of the court, do you believe she's not competent to go forward? Under the Michigan, under the law in the state of Michigan, do you believe she is competent to go forward?
Yeah, I don't think she's incompetent, put it that way. I mean, she's able to communicate with me, yes, but maybe, not at the best.
All right.
Especially with somebody that has a pounding headache. I mean, I can just imagine.
Did she take any medication for headache or aspirin or
I don't think they
ibuprofen or
any medication today.
Okay. Is that something she normally would take for a headache?
She's
okay.
Oh yeah, she does. She has a thyroid issue. She pointed out to me that it's protruding. She's undergoing testing. Won't know the results for another couple of weeks if it's cancerous or not. There is a family history of that as well.
Okay. Ms. Blomquist.
Thank you, Your Honor. Well, I was going to argue that she's presumed competent until she shows otherwise, but given that's not the claim, then the argument would be whether or not there's good cause for an adjournment, and it's the people's position that a headache is not good cause. Additionally, the people are ready to proceed and put, one, with the Ginther hearing, but two, we do have some evidence that we could set forth to make the record as it relates to her appearance and how she was on the transport on the way here. We did have after the in-chambers discussion, jail medical came and looked at her, and it seems that she's been cleared by them, apart from having somewhat raised blood pressure. So I do think that we could make a record as to why this is not good cause. Additionally, Ms. Vander Ark, through her counsel, did give a waiver of HIPAA so that we could request some records from MDOC. They said that those would be emailed to me in approximately 30 minutes. They were going to do that expeditiously. However, the people would put forth as an officer of the court that in communications with the Michigan Department of Corrections, they would not have transported her had there been a medical issue raised before transport. So, Your Honor, I think this is just, again, another dilatory tactic by Ms. Vander Ark to delay this hearing and to delay the proceedings. And I would say that there's not good cause. And additionally, I think the court can take into consideration all of the prior actions of the defendant, her prior reports, all of that when fashioning whether or not an adjournment is warranted. And it's not in this case, and we should proceed.
Okay. Did anyone, We obviously have the Department of Corrections officers in the courtroom. Did anyone talk to them regarding her condition?
I did, Your Honor. I did inform them they may be needed to take some brief testimony.
Well, short of that, I mean, are either one of you comfortable doing that?
If you would like us to, we can.
Okay, well, why don't we have one of, what's your name, ma'am?
Officer Scott.
Officer Scott. Why don't you have you come on up, and I'll swear you in. What's your first name, ma'am?
First name's Autumn. A-U-T-U-M-N.
All right, Ms. Scott, can you raise your right hand? Swear it up, and did you swear or affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, put your hand down and grab a seat. Can you please state your name for the record, spelling your first name and last name?
First name is Autumn. A-U-T-U-M-N. Last name is Scott. S-C-O-T-T.
All right, any objection with me asking some questions, and I'll let you guys follow up. Mrs.
Your Honor.
Bloomquist, Mr. Ambrose?
No.
All right, good morning, ma'am. I'm sorry you're in this position. This doesn't usually happen. So,
That's okay.
my understanding is you transported Ms. Vander Ark here this morning. Is that correct?
Correct.
And where did you transport her from?
Women's Huron Valley in Ypsilanti, Michigan.
Okay, approximately how long is that
About
ride?
2 hours and 45 minutes.
Okay. And now, I kind of understand the configuration. Are you in the back with her in the van, or are you driving in the front? How does that usually work? Where's everybody in the van? Without getting into...
It's okay. I was driving. My partner was in the passenger seat, and Miss Vander Ark was in the back.
Okay. So you were more focused on the road?
Correct.
Okay. All right. So we probably need your partner more. A little bit. Now, were you able to observe Miss Vander Ark?
I can see her through the rear view mirror as I drive.
Okay. Was she communicating with you at all?
She only spoke to us a couple times just to ask to turn the heat up or down.
Okay. Did she indicate that she had a headache at all?
She did not. When we arrived, she did say that she was feeling a little nauseous,
Okay. All right.
a little dry heaving.
Okay. Anything from... Was it... No. Okay. All right. Did you ask her what it was from? Was it from the ride or something like that, or you know?
She did say she does get car sick.
Car sick. Okay. All right. To your knowledge, would the Department of Corrections transport a prisoner if they had a concern over her medical health?
No, and if she would have expressed it to my partner, then my partner would have requested to have healthcare come and clear her before we leave.
Okay. All right. Okay. All right. Technically, Mr. Ambrose, this is your hearing, so unless you want to go ahead, Mr. Ambrose.
I don't really have anything.
Okay. Ms. Bloomquist?
Just briefly, Officer Scott, was she conversational?
She didn't talk much. Like I said, just to ask us to turn the heat up or down for her. Other than that, she was quiet.
Nothing further.
Okay. You can stand down. Thank you so much. Do we want to put the other Department of Corrections officer on? Anybody input on that?
I'll leave that in the court's discretion, Your Honor.
Mr. Ambrose?
I don't have an opinion on it.
All right. Any other argument before I make a ruling on this, Mr. Ambrose?
Well, just that she did mention that she was nauseous, and that's consistent with, her headache, which she reported to me.
All right. Ms. Bloomquist, anything else?
Yes, Your Honor, I just would ask the court take judicial notice that Ms. Vander Ark, during this motion to adjourn, has actually been assisting Mr. Ambrose in the proceeding with writing notes to him about if she's taken any medication or if she has done anything to assist in in remedying her headache. So I think that I just wanted that to be on the record because I don't think the transcript would necessarily catch that. But as an observer in the courtroom, she has been actively participating in this motion through her counsel despite her claimed ailment. So again, I don't think there's good cause for an adjournment, and I'd like to move forward.
All right.
Your Honor, can I just say, just my client writing a couple of notes down, is that supposed to be some sort of active participation? I don't think so.
Well, Mr. Ambrose, we're kind of in a catch-22 because I can't ask you what she's been telling you, and what kind of. I can't judge how much she's assisting you without getting into what she's talking about. So I'm observing her writing notes and talking to you. Which I've had jury trials where the defendant doesn't say anything to their counsel, and so why don't we do this? The court also has experience with Ms. Vander Ark. Several times during the proceeding, during the jury trial, there were breaks in time where Ms. Vander Ark said she was undergoing distress. I granted those breaks. it seemed to me, and you know, from the outside looking in, that these medical issues seem to be at times of pretty significant testimony in the trial. Not saying that maybe they weren't genuine, but they certainly certainly appeared to be situational. Also, when she were at a preliminary examination down in district court, there was just a point of what she's claimed to be distress that appeared to be situational. We're here now, and I think it seems to be situational again. Again, she may be going through something, but I understand that you know, adjourning this wouldn't necessarily prejudice the defense. However, you know, there's witnesses here, they're ready to go. People took time out of their schedules. The court set aside an entire day for this. And there is something to be said for the swift administration of justice here. And so, based on this, based on what I have, I don't think there's good cause for an adjournment based on a headache, because that's all really the record's been made. And the only person that can judge if she really has a headache or not, quite frankly, is Ms. Vander Ark. And I don't know if she's telling the truth or not. I have no clue. I will say, as the finder of fact at the trial didn't find her credible, and I don't know how much credibility the court can lay on her statements. So I'm willing to do this. I can take a break, wait for the records to come in. That way the court can review those. I also can offer Ms. Vander Ark, is our jail staff allowed to give her medication, like ibuprofen or Tylenol or something like that? Is that allowed?
I would assume if they discuss it with healthcare at the prison, that would be fine.
Okay. All right. So I don't if we have something downstairs. She can, I mean, I don't know what she takes, Mr. Ambrose. She'll let me know. I'm sure they have it all on. We can do anything we can to help with that. I'm willing to give her, you know, if she needs for blood pressure, I don't know, maybe she needs food or something, I don't know what it is. So anything that can accommodate to help her headache, I get it. If she's got a pounding headache, then I want to at least try to get her some help for that. So why don't we adjourn? We'll wait for the records to come in. Mr. Ambrose, let my staff know if she needs medication, and we can get that from the jail. And then we'll go from there. Anything else before we break, Ms. Bloomquist?
No, Your Honor.
Mr. Ambrose?
No, thank you.
Okay, we're in recess.
She has a headache, and slightly raised blood pressure. Wonder what everybody in the courtroom has as well. You think the judge has a headache after dealing with her? How about the prosecutor's office? And how about her first attorney, Fred Johnson, who you could see sitting in the gallery waiting to be caught? But they all have headaches and slightly high blood pressure this morning. Well, this woman is something else. The lengths that she will go to manipulate, stall, delay. How about how the judge called her right out and said the jury didn't find you credible, and essentially neither do I, Ms. Vander Ark. And so in an abundance of caution, he's going to get those medical reports from the jail, enter them into the record, presumably so that she can't try to come back and claim that there was some kind of competency issue or something going on this morning. It's a headache. A headache. Maybe you have a headache at home thinking about her and what she did to her son Timothy, her son who was 5'8" and weighed 69 pounds at the time of his death because he was starved to death. He was tortured to death. This is a child abuser in the courtroom, a convicted killer in the courtroom with zero credibility. And now she has her a chance to shoot her shot, so to speak, on this ineffective assistance claim that she's making, but she wants an adjournment because of her headache. You can't make this stuff up.